Agency Placed Foster Care versus Mark Allen Rush, and Agency Placed Foster Care versus Alyssa Marie Walsh. This would be the defendant's motions to abate child support and clear arrearages. Mr. Rush appears in the courtroom. Ms. Walden appears via the Zoom application. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
Thank you. You may put your hands down. Can we hear from the front of the court first?
Certainly, Your Honor.
These are Ms. Walden's motions in the two companion family support cases. The children at issue were placed into care on April 4th of 2023. And while I acknowledge the argument in Ms. Walden's motion about there not being jurisdiction in the companion file, the support program is actually only looking at the placement of the child. And as of this morning, both D and C remain out of home.
Very well. Who wishes to speak first, either Mr. Rush or Ms. Walden?
It's her motion, she can speak first.
Okay, go ahead. Ms. Walden,
Hi.
go ahead, please.
I didn't hear
Good morning.
Anne had stated the last statement she made. Can you repeat the last statement she made about?
Sure, Ms. Schultz, can you repeat?
Correct. Friend of the court records show that as of this morning, both C and D remain in out of home placement.
They're out of placement?
They're in out-of-home placement.
Yes. Okay. So I had done some research and had talked to my lawyer about the child support situation. It is actually on the Michigan Legal Help.org website, regarding like CPS and families and stuff. And technically child support is not supposed to be ordered until after the dispositional hearing, which occurs after the trial and after the courts get jurisdiction of the kids. So that's why I filed this motion, because technically child support is not supposed to be ordered until then.
Ms. Schultz, do you have any comment?
I don't have that information, Your Honor. The 4D program instructions only reference placement. Jurisdiction and disposition are in a companion file. They have nothing to do with this act.
Any other comment?
It has nothing to do with the child support. Is that what she stated? Sorry.
Repeat your. Sorry.
What I had indicated is that jurisdiction and disposition are under the companion file. The actions before the court today are only related to child support, and our 4D policy manual is that we look at placement of the child.
Well, because jurisdiction hasn't been given to the courts, and I mean, I can provide Ms. Schultz with the website that I had found the information on to prove that it is, you know, a real source that child support is not supposed to be ordered until the dispositional hearing. So I'm not even understanding how it was able to be ordered in the first place without the jurisdiction being made.
Anything else?
No, I guess not.
Mr. Rush, did you have anything else?
I do agree with her. I had spoke to my attorney as well, Mr. Lockhart, about this, and he did state the same thing. I understand where Ms. Schultz is coming from as it pertains to child support. She said is based under the front of the court case, but nobody has custody of the kids, which can't grant child support. Child support would have to go under the NA file, and if the court doesn't have jurisdiction and there's no dispositional hearing, can't grant child support.
May I just clarify one thing on that, Your Honor? Sure. I didn't reference custody of the child. It is only placement, whether they're out of home or not out of home.
Right. We have here the support file. There's a companion file, an NA file, which we need not discuss, but that's part and parcel of this. This affects this is regarding placement, not custody or anything else like that. As a result, and I'm not aware of anything to the contrary. Respectfully, the motion is yes. Mr. Yarborough's motion regarding parenting time. He's present in the courtroom. Ms. Zinger is also present in the courtroom. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Just by review of this file, the court had suspended father's parenting time based upon an allegation regarding the minor child. that has continued. Mr. Yarborough is asking that that provision be lifted. Part and parcel of this, there was a criminal charge brought against Mr. Yarborough. One count, as I recall, and the court takes judicial notice of its own record, specifically the district court file of People versus Sean Yarborough. Mr. Yarborough was charged with abuse in the 4th degree. He was charged with domestic violence as well. The matter was eventually resolved as the court understands it. There was a plea to the domestic abuse count, was dismissed at the time of sentencing. And for disposition in the case, beside other sanctions, so to speak, imposed by the district court, the court continued the no contact provision between Mr. Yarborough and the minor child based upon the circuit court's prohibition, so to speak, of Mr. Yarborough having contact with the minor child. So, as I understand it, reading the Register of Actions, the district court only left that provision in based upon the circuit court's ruling in this case. Is there anything from the front of the court regarding this issue at all? Ms. Schultz?
The only thing that I would add, Your Honor, is that it's my understanding that there's been a probationary term after sentencing as it relates to the district court matter. So otherwise, I'll defer to the first discussion.
Okay, thank you. Mr. Yarborough, why do you think we should lift this provision?
Because mistakes have been made, and I did not abuse my child. I never will. And I think that with everything,
Well, just a moment though. You pled to domestic violence.
yes,
Let's just be honest.
I did that to get the whole process get done, started, and finished as soon as possible to get everything back in order to get my son back.
Okay.
So, and so I thought maybe doing that and doing all the ordered provisions that that would help with the case, getting everything back to order. So, which I did the domestic violence class. I'm doing community service, working on paying my fines. So I just thought maybe it'd be the process of getting everything started back in order.
Okay. So when's the last time you've seen the child?
Over a year ago, since when all this before this all happened.
Any phone communication, any Skype or FaceTime or anything like that?
Nope, I've not contacted him one bit at all.
And I appreciate you not mentioning the child's name, but how old is W right now?
8.
So what, if any, changes have been made in your home regarding moving forward as it pertains to W?
And over the time I've taken the time to sit back and think about everything that's been going on back then, and realized I've had some slight anger issues, and I think the meds at the time I was on had maybe affected that, and I'm no longer on those meds. And I've also been seeing my other child on a regular basis on my order time every weekend, and there's been no issues. He's not as scared to come to my house. He has
Right,
fun.
but I ordered that.
Yes.
This court entered that.
Yes.
Because that was not the child involved in this
Right.
practice.
I was just saying that it's just proves that my other child, you would think that he might have been scared of all this in the first place, but he wasn't. And once I got back on my feet with a job and everything, he was able to come back to me, and he comes to my house every other weekend like he's supposed to, and there's no issues.
So when I asked about if there were any changes, all you mentioned was you're no longer on the medications you believe caused the problem.
Right.
But I'm assuming you went to an anger management program.
Yeah. I was ordered that a long time ago, and I completed that.
When did you complete that?
That had been back in 21, I think it was. 2021.
Before the incident?
Way before, yes. Yeah, I believe you ordered me to have anger management way back then.
What else did the district court enter regarding things and programs you'd have?
There was domestic violence class,
Yeah,
community
what's that
service.
about?
It was a 4-hour class that I had to call and set up myself, which I did, and I completed it back on, I forgot, it was a few weeks ago. I forgot the date it was. January 27th it was. It was just discussed what was going on, why we were there, any ways to communicate better, or how to address things or approach things in any kind of situations like that with anybody.
Who sponsored that one?
Cammy something. I can't remember the last name, but
Edmonds?
yeah, I think that sounds right. Yep, yep.
Okay. What else did you do?
We talked with, as a group, with the other, people that were in there. We talked about each case individually. We did a little, I guess, a little writing assignment thing that, to help us actually see on paper and discuss it with the, sponsor.
Were there any services provided by the Department of Health and Human Services? DHS or DHHS?
Besides that, I don't think so.
Oh, so they did the,
I think, I don't, was it I can't remember if DHS that did that or not.
okay.
Not that I remember anyways.
Okay. Anything else before I go to Ms. Singer?
No, not I can think of at this moment.
And Miss, I don't know, is it still your last name Singer or, no, it's Wilder.
Yes, Your Honor.
I'm sorry.
That's okay, Your Honor.
I just looked at the latest tweets, so.
I get name changes take a little bit, so it's okay.
Ms. Wilder, how do you respond to this?
Obviously, it's not an easy matter, no matter how you look at it. I firmly never believed that would occur in Sean's home. He is right when he said he was charged with child abuse, 4th degree, and domestic violence. It was a lot of dragging out, rescheduling, and then he finally just agreed to plead guilty to domestic violence, hoping it would just go away. And I feel it's not something that should just go away, because for W, it doesn't go away. He is in weekly counseling, sometimes twice a week, because of this issue. Since this issue has arisen, he has shown an increase in anger issues, and that is the main focus of his counseling right now, is anger. The no contact order with W was entered February 5th of 2023. There has been absolutely no contact for over a year. Mr. Yarbrough was ordered 6 months probation with not an option to be released early. So his probation will end on June 28th of 2024. W is 8 years old, but he is a very smart 8-year-old boy for what he's gone through. He has some mental issues he is going through because of this, which is understandable. I feel W will come in and tell you, he's wrote a letter to the district court judge that Mr. Yarbrough read, his lawyer, his attorney read, and the district court judge read. I don't know if it was sent over in the file or not. He was more than willing to come in and speak with you. I ask that if you are considering reinstating parenting time unsupervised, that you speak to W first in front of the court does an investigation for parenting time. DHS has imposed a safety plan with Mr. Yarbrough. I'm unaware of what the safety plan entitles. I was never given a copy of it. Been doing this on my own for over a year. Nothing's changed child support wise. I'm not here for child support. I'm here for his safety and his mental health, because mental health is huge. And I did speak with her. Around dad in a supervised environment.
That's where I'd like to go with this. We have a year that the child has not seen father. Father made a terrible mistake. He acknowledges that by entering his plea at the district court level. He was sentenced to it. Certain terms and conditions he has to complete. And there's apparently a safety plan with DHHS or Child Protector. I'm not sure which. Mom states it, but we don't have that for us. So what the court wants to do in this matter is we need to hear from therapists, because therapists would be best able to give the courts guidance as to how this child is proceeding. And the idea of the counselor sitting down with mom and dad, or dad and the child, I don't know how it would be done. I think it'd be a really good idea. So I'm not precluding Mr. Yarbrough your motion. The court is taking it under advisement, but I'm going to request within the next 14 days that an appointment be set up with the parents and the counselor to discuss this issue, to see whether or not a session can be set up or whether it can or cannot. But then we come back in 30 days to see where we're at with this. And if something can be brought up earlier, if the therapist says, you know what, we could do something earlier, notice it up and we can hear it even earlier. Or if there's an agreement reached between the two, court is more than willing to move forward with that so long as it's in the child's best interest. What I am hearing from other, which is kind of refreshing to hear, I'm not hearing absolutely not, no way, shape, or form. I think she understands that if father is a good father and a fit father, the child should have both parents involved. That's what I'm hearing. But I'm hearing issues regarding how the child's feeling, how with the child being in therapy, and it being over a year. I don't want to put the child in a situation where either A, I'm completely denying any time to dad and it's detrimental to the child, or on the flip side, I just completely immerse the child in with father. The child is not prepared for it. The child's harmed that way. Neither way is a win, and I don't want that to happen. So, can it be set up within 14 days for parents to meet with the therapist to discuss having a group session?
I will call as soon as I leave here, Your Honor. Just so I'm clarified, when they have the session, do you want the therapist to come to court or will a letter suffice?
May I ask Mr. Yarborough, what would you like to do in that regard?
You're saying after we do the meet, you're saying? Is that what you're asking?
Right, whether or not a letter, if something can be reached between the two of you and a letter from the therapist, I'm fine with that. But if it's going to be contested, then we'd have to have the therapist come and contest it.
The only reason I ask that is because I had to pay last time to have the therapist subpoenaed. So if he's wishing, I would ask that he pays.
Sure, that makes sense. That makes sense. So what I want, Mr. Yarborough, you have to work with mom, schedule that time, meet with the therapist, discuss this idea of a group session. Let's hear the recommendations of the therapist. If something can be worked out, as I said, wonderful. We'll order it based upon a stipulation or agreement of the parties. If it cannot be agreed to, then we need to have the therapist come in. And the cost of the therapist coming in would be your responsibility.
Okay.
Any questions?
I do have one thing. I spoke with, is it Mrs. Schultz or Miss Schultz? Sorry, I just don't want to address you improperly.
Either is fine.
Okay. I am having communications issues with Mr. Yarborough again. I am sending messages and just being left unread. I've requested permission to enroll him in ball because one thing his therapist said is to try and keep his routines as normal as possible for him, even with all this going on. I'm getting no answers, Your Honor. Nothing.
Mr. Yarborough, now's the time to open up for communications if they are close.
Most thing is though, with the no contact order, I didn't want to risk saying something to her and she tried to use that against me.
Well, there's not a no contact order between you and mother. It's you and child.
Even though it's about the child?
Correct.
Yeah, that's why I didn't know.
If it's about the child, that's one thing. But if you're speaking or contacting the child, that'd be a violation of court.
Well, I didn't know the risk chances, so that's why I was playing it safe.
Good question. And both of you need to communicate. Because we had a good run there for a bit too. Don't forget how bad this started
Oh,
and how it turned around. That's where I want it to be because this is a bright young man.
can we place it on record? Can he do ball?
Yes.
Okay, thank you. Registration closes today, so.
The court has ordered that Mr. Yarborough would be responsible if
Subpoena.
Caitlin is required to appear for testimony. Are you ordering that he also prepare the subpoena, or are you asking the friend of the court to do that?
Probably have in front of the court prepared in the event that it gets to that level.
If I could then request that the parties provide me with full name, including spelling.
Yes, I can drop it off as soon as I leave here.
Okay. Thank you, Michelle. All right, let's see what happens. So let's get another date then. Should we get another date or let's do that?
You want to go April 5 or 12?
April 5 or 12?
Can we do April 12th? I'm being induced April 3rd.
Oh, congratulations.
Thank you.
12?
That's fine.
Okay.
Just April 5th is a little soon.
I got it. Okay. All right, Ms. Wilder, Mr. Yarborough, you're all set.
If possible, could I appear via Zoom if need be on April
I don't
12th?
see a problem.
Okay, thank you, Your Honor.
Same with you, Mr. Yarborough. If it's, well, hold on. If it's going to be contested, we're going to have a full-blown hearing. That might be a little bit different.
Sure.
Let's play it by ear.
Okay,
Okay? Thank you.
thank you, Your Honor.
Thank you, Your Honor.
Have a great weekend.
Issues regarding parenting time. Ms. Moody is present. Court had inquired of Mr. Deal. Beecher Deal, Mr. Deal, not in the courtroom. And he's not checked in by Zoom. Ms. Schultz, can you shed some light on this?
Yes, Your Honor. The parties last appeared before the court on December 15th of 2023. And following a child custody evaluation by Ms. Edmonds, the court had instructed that a supervised visit between Mr. Deal and the minor child occur, and that the front of the court would supervise that visit. That was done on December 27th of 2023. After that meeting, Mr. Deal had indicated to me that he wished to waive his parenting time. The friend of the court office prepared a parenting time order to correspond to that request. Ms. Moody signed it electronically. Despite our attempts to contact Mr. Deal, he has not returned any phone calls. He has not responded to letters. He has not signed the order electronically. And so we had renoticed this issue because our last order said that the parties reached an agreement regarding parenting time, or the court would make further determination. So
And it's his motion.
it was initially his parenting time complaint, which the friend of the court said was triggered.
What do we do if he's not here?
I filed it to the court. There is a proposed order in our file, just indicating that parenting time is held in abeyance until the further order of the court.
And that also support.
It will. We're in the process of doing a child support review. However, we haven't issued that recommendation because we needed parenting time to be addressed so that we have an accurate television.
And he's basically been radio silent
Since December 27th, we have not been able to reach him.
Ms. Moody, do you have any comment?
This time, no. My main thing was that Paige got to be heard and his feelings got to be heard about everything that he's been through, witnessing with his dad, and they were, and I was happy that his feelings and everything were being able to be taken into accountability because he is 11 years old now. And then yeah, December 27th was the first time that he's seen his dad in a handful of years. And then he's seen him that day for that little bit. And then
Did you say a handful of what?
handful of years.
Years?
Years.
Oh, years.
Yeah, he hasn't seen his dad
Wow.
since like 2019. So it's been quite a while. And that was the first time we've seen him. And it was only maybe a handful of minutes of that. And then we haven't heard or seen from him since then.
He's not reached out at all. Well, Ms. Schultz. Any time remains suspended until further order of the court.
Thank you.
What else can the court do? And I don't know how the visit went, but if it went okay, or if it's productive for the child, it's certainly a waste for the child.
I think it gave her some closure, to be honest with you.
I understand. You're all set. You're pretty good. Thank you. Oswald versus Mark Stephen Page II. This is Ms. Oswald's motion regarding taxes, withholding clothing, and other matters. Ms. Oswald is in the courtroom. She is in pro se, which means she represents herself. Mr. Page appears via the Zoom application. He is in pro se as well. Before we begin with the motion, I'm going to ask Ms. Schultz the policy relative to withholding of clothing and other items. Ms. Schultz, could you help us out there, please?
Certainly. Friend of the court's policy is that a parent is not required to send any items with a child. The parent exercising visitation is responsible to provide for all of the child's needs. Should those items be sent, then they should be returned. A favorite toy, a blanket, a book, it should come back with the child. It should all travel with him or her.
Ms. Oswald, what is the issue regarding that?
He has been keeping the child in question's toys. He's been keeping her school clothes. Like, I'm having a hard time keeping the clothing that fits her that has been bought for her up here.
Okay. Mr. Page, your response to that issue?
Well, I've also sent her up there with multiple outfits, and the clothes she keeps sending my child down in are too small for my child. I've had to buy my child multiple pairs of underwear because the underwear she sent her has been well over too small. And every time she's come down here, my child is itching herself because her underwear are too tight that her mom put on her. So yes, all her too small clothes that she sends her down here in, I throw away and buy her new ones. She still has outfits that I've sent up there that I have yet to receive back.
I have had to replace the clothing that he has been keeping that is the correct size. Because like I said,
Just a moment, sir. Go ahead.
we had bought her a couple of new shirts for Christmas time. I have maybe one of those left. We ended up just going out to the store the other day, picking up a couple more long sleeve shirts to wear under her short sleeves so that she can stay warm in the cold weather. That's still missing. I still have yet to receive the winter hat back that I had sent her down in when it was snowing.
So we have at least one of the new Christmas shirts, 2 long sleeve shirts, and the winter hat. Is that correct?
Yep, along with, as silly as it's going to sound, one of her dinosaurs that she enjoys taking everywhere with her. She's a dino fanatic, and she took one of them down, and those things aren't cheap. They're the Jurassic Park Mattel ones.
Probably the same one I bought.
Sir, just a moment. So we have at least one new Christmas shirt, 2 long sleeve shirts, winter hat, the dinosaur toy, correct?
Yes, sir.
Anything else?
Not that I can think of at this very moment.
Okay. Mr. Page, what items are you claiming need to be returned to you?
All of her undershirts, all of her underwear that I've sent her up there with, all of the outfits that I've sent her up there with, being one shirt saying big sister on it, another shirt saying adopted, like adopt, like to adopt like animals and cats and shit like that, stuff like that. My apologies, excuse my French.
Like
A couple of pairs of pants.
Sir?
Yes, sir.
We don't use those words in the courtroom. You're in the courtroom, sir.
My apologies, and I excuse my French for that. My apologies.
So let's break it down here. Be more specific. What clothing do you claim that you've purchased that you are missing?
I've sent her brand new undershirts, brand new pairs of underwear that I have yet to receive back. 3 shirts that I've sent her back since her birthday in November that I have yet to receive back. Multiple pairs of pants.
Can you
3 or 4.
3 shirts?
One of the shirts says big sister on it. Another shirt says adopt on it, like the word adopt for animals and stuff like that. And it's got a hood to it. And there's another shirt. I can't quite remember what the shirt is, but I know it's a short sleeve shirt because I put it on top of a shirt that she sent her down here with. That was too small for my child. I have multiple pairs of pants that I've sent up there, 2 pairs of blue jeans, a pair of black jeans that I've sent up there. Also the hat that I purchased her for her birthday in November that she was wearing and stated to her mother that she liked to wear that hat. But yet the last 2 times she sent my child down here, she sent her down here with no hat, knowing that it's going to be cold.
What does the hat look like?
It says justice on it with a poof ball on top. It's like a cool grayish color. I've sent her up there with a pair of matching gloves for that very same hat that she has yet to send back with her. But she wants to sit here and, try to make me look like the bad guy. I didn't even know about this court date. I didn't receive any paperwork from you guys about this court date. The last paperwork I received from friend of the court was my receipt on my complaint that she decided she wanted to show up late, dropping my daughter off February 20th, right after, and the 16th, after she finally found out that she was getting child support from me. It's mighty funny that it's
Mr. Page, let's focus on this hearing right now. The proof of service, there was a certificate of mailing on February 7th from the county clerk's office, and it's sent to a Michigan. Is that your address?
Correct. This is my mother's address where I reside and my mail sent. She tells me when my mail gets there. I have yet to receive that. The last piece of mail I received from you guys was a receipt on a complaint that I put in. That was the last piece of mail that I received from you guys.
So that's not a good address. What is the address that it should be sent to?
The address is 44,000 Michigan.
Okay. Well, there's a certificate of mailing on the very same day, February 7th, by Ms. Thomas from the clerk's office being sent out to that Michigan Avenue address, but I can't explain why you didn't receive it. So let's get back to the clothing then. Did you hear the list that he provided?
The black jeans that he had mentioned, those are ones that were purchased up here. Those are ones that fit her for school. The blue jeans he had mentioned, they're size 7. They do not fit her. She straight looked me dead in the face and said, "Mama, these don't fit and they're hurting my tummy. Can I take them off?" And I'm not going to leave her in too tight of jeans.
Okay, so why not give those back to him then?
I had forgotten to have them put into her little book bag to take with her. They'll be put in there today.
Let's return those. The black jeans, though, he said he purchased those. Did you purchase them?
In all honesty, Jaleesa used to be, I don't know if it's Soper or Ranger still on government papers, but she had helped me purchasing my daughter's clothes for the last couple of years. And this is while I was with Mr. Page. So those were bought way before he and I even ever separated.
Okay, so why can't the child wear those jeans not only to mom's house, but to dad's house?
And I have no problem. Like, the problem is I'm not getting those pants back because they're school clothing. Before I was receiving the first installment of the child support that he had mentioned, I've been on a very low budget. So I've been working with the clothing that the little one had already had.
Okay. What about the 3 shirts for child's birthday purchased by father, big sister, adopted, and the short sleeve shirt that apparently is too small?
The big sister shirt he purchased for her for Christmas, and he himself told me, I don't know where that shirt came from, just throw it away.
Never said to throw it away.
Do you still have that shirt?
Somewhere possibly in all of her laundry, it could still be there.
Okay, put it in the little bag.
Definitely can.
What about the adopted bag, the adopted shirt, the hoodie?
The shirt that came with the hood, she wore down to, and he kept within the last few times that she's gone down there. Because I asked her which shirt she wanted to wear down there.
Okay. Do you have any undershirts, underwear of the child as well?
The underwear I have been having to keep, I will honestly admit that, because he has been continuously not sending her home in the underwear that was already provided. They are the same size underwear that she has with every other pair that she has with me.
They really aren't.
Is the child in a growth spurt right now as well?
Yes, sir. She is eaten and growing like a weed. She has shot up at least a ½ inch in the last couple months. Like, she has, after I leave here this afternoon, I was going to attempt to try and get her even more clothing to reduce the clothes that are missing or not fitting.
Okay. So I'm going to ask you first, and then I'll go to Mr. Page here in a second. Any of the clothing that he may have purchased, including the justice hat with the poof ball on top and the matching gloves, can you get that returned to father?
I have no problem with that, but if I return that, I also need the hat back that she wears for
I'm
winter.
getting there. I'm getting there. Are you willing to do that if we can take care of the new shirts at Christmas, 2 long sleeve shirts, the winter hat, and the dinosaur?
I have no problem with that.
Okay. Mr. Page, can you return, when the child returns, the remaining new shirt that mom purchased at Christmas, the 2 long sleeve shirts, the winter hat, and the dinosaur?
Supposed long sleeve shirts that she sent down here with my child. Because the last long sleeve shirt she sent down here with her, I sent her back with that Sunday, which was a pink flower shirt.
Can you describe the 2 shirts, miss?
I am missing multiples. I am missing at least 1 long sleeved black shirt. I am missing a hot pink stitched shirt that my sister put the picture on for me. I am missing a light blue long sleeved shirt. Like, it's all her undershirts to wear under her short sleeve shirts. Those are just the ones that off the top of my head, I know for sure I'm missing. There might be a secondary long sleeve black one also.
Can I make an
Because I
objection?
went all of laundry and I can't find those colored shirts right now. I went through the dirty clothes and the clean clothes today before I came in.
What's your objection, sir?
I literally have my mom sitting right here next to me. Every time she sent my daughter down here to me, she has never had an undershirt on, unless it was a regular shirt. I've sent her up there with undershirts every single time and have yet to receive any single one back. So why she
Majority of the
sent
one,
that for me, lying to you guys about undershirts? Yeah, that's not cool.
Okay. I've heard enough on the clothing issues. Let's talk about the taxes, Mom.
I had gone to file taxes in the beginning of February and had my taxes denied due to the factor that he had already claimed her.
Well, yeah, because for 2023, I took care of you and her more than 6 months.
Mr. Page, just a moment. Is there anything in any court order that identifies what year a parent may claim the child?
We had never gone over that in court yet.
Okay.
And with just the simplicity of the factor being that it would be something that would need to be brought up here because of this type of situation. I would just rather have it taken care of.
Okay. Mr. Page, you claimed the child then, correct?
Yes, I did, sir.
And you can receive a benefit because you are employed, correct?
Say it again?
I said you did receive a benefit because you are employed, correct?
Correct.
Okay, just simple question. Mom, you are employed as well?
Yes, sir.
Okay. So my proposal would be, since it's not been addressed, is that.
Can I address one thing, Your Honor?
Go ahead.
Me filing my taxes for the year of 2023, she was not working. She recently just got the job she just got when she moved back up there.
Okay.
In 2023, I took care of her and my daughter for over 6 months. So I had every right to claim my child on my taxes.
Well, what I'm proposing is simply this. You've already claimed the child for 23. My proposal is that mother claims on the even number tax years, father claims on the odd number tax years. In any year that the parent cannot receive a credit, let's say the parent's not working that year, then in that particular year, and that particular year only, the other parent may claim the child so not to lose the benefit.
I have no problem with that.
Sir, do you have any problem with that?
I have no issue with that at all, Your Honor.
Okay.
My only curiosity is, for the factor of the taxes being carried on from last year before any of this even went on, she only stayed with him for literally half of the year. Would it be at all possible for me to receive the other half? Because she has been in my custody since down to the date of June 21st, when we got put out of the trailer in Ypsilanti.
You also had no job.
Mr. Page, please. I'm going to make my ruling now. I am going with father claims for the 23 tax year, which he's already done. Mother claims on the even number tax years, father on the odd number tax years moving forward. In any event where the parent cannot receive a benefit, then the other party may claim for that particular year. So you'll get the full benefit next year rather than just half. That's my ruling. Relative to the clothing in this case, the court is going to order as follows. Father is to return to mother by the end of the next visit one long black sleeve shirt, one long sleeve hot pink stitch shirt, a light blue long sleeve shirt, a winter hat that she purchased for the child, and the dinosaur in question. That's what mother is to receive from father. Father is to receive all the undershirts and underwear he had purchased, the 3 shirts for her birthday or Christmas, which include the big sister shirt, the hoodie that says adopted on it, and the short sleeve shirt that's too small. The jeans, there are 2 pair of jeans. The blue jeans, I believe, are to be, not believe, but those, the one pair I find was mother's purchase is to be returned to mother. The black pair sounds like it was purchased while the parties were residing together. So as far as the court's concerned regarding the black pair, the child should be able to wear them with father and with mother. The pants should be worn whenever the child wants to. Also, the hat, the justice hat with the poof ball on top, and the matching gloves are to be returned to father. That is to be done by the next completed visit. When's the next visit going to be? Is it this weekend?
Today.
This evening? Today? It's probably too early to do it. Can it be done today?
I can collect all the things when I get home.
Okay, do that. Let's do it today. And then when Sunday, I'm assuming the child returns on Sunday?
Yes, sir. At 6 p.m. she's supposed to be
And then father will have his items that mother needs to get, and those are returned on Sunday. That's all. Thank you, everyone.
I have one other quick question concerning everything.
Go ahead.
What are we supposed to do about the derogatory remarks that he has been making to the child about me?
Well, it's not before the court because there's no motion before the court. It is? I'm
Yes,
sorry,
sir.
then I missed it. I saw and other items. Oh, yes, last paragraph. Has that been ordered, Ms. Schultz? Derogatory comments?
In the first hearing that we had, you had,
The order does require that the parties utilize app close for purposes of non-including the calendar feature. that communication be limited to issues involving the minor child, and that neither party shall speak in a negative or degrading manner about the other parent, and are prohibited from discussing adult topics with or.
Okay, thank you. I missed it. I apologize.
You're okay.
The paragraph reads, he has also been telling our child that I am selfish, evil, manipulative, and a liar. I don't speak negatively about him, yet these are things he says directly to our daughter, who's 6 years about. Mr. Page, how do you respond to that?
I'm going to respond honestly. Yes, I have told my child that because my child comes to me telling me what my question is, if she supposedly hasn't been speaking bad about me or my situation, why does my child wait until I walk away to ask my current girlfriend, what's your name? What do you look like? My mom has shown me a bunch of pictures of you to try to see who you look like. Where's this you stay? What's your address? Specific questions that I know she's asked my daughter to ask her. She constantly interrogates my child like she's a prisoner every single time I drop my daughter off trying to figure out who my girlfriend is and where I stay. And that's evil and manipulative. So me being honest with my child shouldn't be illegal when she's really doing this. When my child comes to me and tells me these things.
Mr. Page, there's an old saying, two wrongs don't make a right. And I'm not saying what mother is allegedly doing is right. It's not right if it indeed is happening. The whole idea here is the best interest of a 6-year-old child. That's it. But if that is happening, the best method is not to take the law into your own hands. The best thing to do is to bring it to the front of the court's attention or the court's attention, and we can address it. But you've admitted under oath that you've done this, and there's no place for it. Nor is there any place, if it's true, that mother is quizzing the child as well. Mr. Holwick stood up. Mr. Holwick?
Your Honor, the parties were ordered to complete the SMILE program, and our file indicates that neither one of them had completed SMILE today.
What's that order? Okay. Thank you. So, Mr. Page, I find you in contempt for violation of the court order. I'm going to assess a $100 fine. That fine, sir, will be due by March 22nd, payable to the front of the court's office. In the event, Mr. Page, you discover that this is ongoing regarding mother, file a motion, and believe me, we'll address it, just like we're addressing it here right now.
Okay, well, can I address the fact that my child also told me that she's basically never home with her?
Well, that's hearsay, one. And number two.
That's coming from my 6-year-old daughter. That's not hearsay, sir.
No,
that's literally what she tells me.
No. Under the rules of evidence here, under the rules of evidence, a statement made by another person, the matter asserted, the truth of the matter asserted, is hearsay. I have to follow the rules of evidence. I hope it's not true. But if there is an issue with it, file a motion, contact the front of the court. We can address it. Did I cover all your motions?
I think everything was covered, yes. May I make a statement to Mr. Holwick about the SMILE program, please?
Well, I want to finish up with that. That was ordered. It needs to be done. Why is it not done?
I had sat down and I have watched the video multiple times. I don't understand why it wouldn't have gone through on the program.
You have to go all the way through the credits. When you get to the end of the credits, there's a pop-up that will display that says select your county. You're on, you type in your email and we get an auto notification that the program is done.
I could.
You have to go all the way through the credits before you can get to that point.
Okay, that part I did not know. I appreciate being told that part. That is the only reason why mine hasn't shown up completed. I didn't know you had to go through all the credits.
If you have done the program but didn't get to the selection where you can select Huron as the county, please send us an email to indicate the approximate date that you did the program and we will grant credit.
I can definitely do that.
Mr. Page, you can do that too?
Yes, sir, I can.
Okay, sounds like you watched it, correct?
Yes, sir, I did.
Okay. Follow Ms. Schultz's suggestion regarding an email. That'll take care of that matter as well.
All right. I appreciate it.
Go ahead.
May I make one suggestion before we go off the record, Your Honor?
Go ahead.
As it relates to the clothing, the parties may wish to just have one dedicated outfit that Dee travels in. So she goes down for business on Friday in the same outfit, that same outfit comes home on Sundays.
I have no problem with that.
It's a good suggestion.
This is.
Let's see how it works.
Is Thompson's motion regarding parenting. Parties are present. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. So, Holbrook, please.
Your Honor, this is actually a friend of the court notice regarding parenting times. Mr. Allen had filed a complaint with our office, received on January 19th, 2024. The same day we had received that complaint, he had also filed his own parenting time motion. 24. Neither party showed up for that hearing, and as a result, the motion was denied. Nevertheless, Your Honor, we had Mr. Allen's motion or complaint that was filed with front of the court office, which was the exact same as his motion. So front of the court took no action on that complaint as it was already set for hearing. Subsequently, after that, we received a complaint from Ms. Thompson that was responding to his complaint, but also a complaint of her own. No action was taken on that because, again, we were coming to hearing on February 2nd. Neither party showed up. Our office received complaints, and as a result, we had set today for a hearing on those complaints regarding parenting time and had them addressed.
What other complaint?
Mr. Allen is alleging that he has had one or both of the children in his care since December, and then this with little to no contact from Ms. Thompson. Ms. Thompson in her complaint is stating that she had asked Mr. Allen to keep one of the children because of a remodel for daycare, and now he's not returning the child. So my understanding is that each of them have a child in their custody and will not be returned.
What is the custody and parenting time?
The last parenting time order, Your Honor, is that there's an order from March 6, 2023 that granted Ms. Thompson sole legal of the children. Physical was not addressed at that hearing, so the parties would still have joint legal or joint physical custody pursuant to the October 14th, 2022 order. And parenting time is still that Mr. Allen would have parenting time alternate weekends, Friday to Sunday.
Okay, this might be a little confusing. I'll begin with Ms. Thompson. Ms. Thompson, do you have any of the children right now?
Only one, my first.
Your first, okay. And we'll use the initials for the children's names. What is the initial of the second child that you don't?
Car. K.
K?
Both with K.
Both with K. So this would be little K or big K?
Little K.
Little K. What's going on?
That's what I'm trying to figure out. There's some back and forth going on. It's a little bit of everything going on. So basically, I asked Keon Allen to keep my youngest, which is little K, for about 2 weeks or so until the daycare remodel, but I wasn't going to wait. So I decided to find another daycare. And he agreed to keep him. And when I found a daycare for Carter, little Carter, then he didn't want to give him back.
Okay. What about big K's? Any issues with big K?
No, he's in school.
Okay. So little K is the one that you have an issue with.
Yes.
Have the alternate weekends been going on for big K?
No.
Father's not had any, even requested it?
No. We'll hear from him maybe in a couple of months. It's not consistent.
Can I say something?
You'll have a second.
Okay.
I'm going to get to you in a moment, sir. I'm just trying to get your side first. Anything else you want to add?
No, not at the moment.
Okay, sir, go ahead.
She said I haven't seen Kylan and Paolo in months. Kylan was just at my mom's house with Carter, the same kid that I won't give her to her. Her and Kylan was just at my mom's house, watched with Carter. If I'm not giving her this baby and you won't see him or haven't been talking to him, if you was just at my mom's house with this said baby, why would you not get this baby? You haven't seen him or talked to him. I'm keeping him from you. Why would you not get your baby? She's telling a lie. I always see my oldest son. She was just there with my youngest baby, with my oldest son at my mom's house.
Okay, but as to little K right now, the order says mom has what's joint physical, but you have parenting time or custodial time on the alternate weekends.
Yes, I was supposed to get them every other weekend. Like she stated, she asked me to get him for 2 weeks. When she brought me little K, her exact words were, "I'm not mentally capable of taking care of 2 kids because I am a single mother. So you can keep them."
The plan was for me not to keep him if I was going to stay in Detroit. But from her knowledge, she knew that I stayed in Harbor Beach, Michigan, not too far from here. So that was okay for me to keep my child because she wanted him to go to school in Bad X District. Everything was perfectly fine, sir, up until it got to the point of, well, I've had him this long since December. We are now about to be in March. I'm putting him on my case. That's when the problem became about.
How old is little Tay?
3, he'll be 4 in June.
The oldest though goes to school where?
In Detroit.
In Detroit.
No, he don't know.
I
He
do
goes
know.
to school in Medicine Heights, Academy School.
That's Detroit love. That's not Bad X. What are you?
Well, hold on. We're not, folks, we're not going to get into an argument over this. Madison Heights is in Oakland County. Madison Heights.
Not Wayne.
I'm sorry?
Yeah, and Wayne is in Wayne. Detroit is in Wayne, Medicine.
Detroit's in Wayne, right?
Yeah.
We're talking a different county, but the Metro Detroit area, to
Mhm.
be fair to everyone.
Uh-huh.
But this is what it comes down to. There's a prior order in effect. There's no motion to change custody. There's no motion to change parenting time. Sounds like a matter of enforcing the court order. Court order says the parties have joint physical custody. Father has parenting time, alternate weekends, Friday to Sunday. That's what the order is. That's where we're going with this. So court is ordering that prior orders remain in effect, which means that is it your weekend this weekend, sir? Or is it next weekend?
It will be next week.
Next weekend. So next weekend, you'd have Big K and Little K, Friday to Sunday.
And I have a question. What is alternate weekends? That's every other weekend, right?
Every other weekend.
Okay.
Right, every other weekend. That's what the prior order said. And as of right now, when you get back, Little K is returned to mother.
So how does, sir, I just don't understand that. She dropped off Little K. Ain't tried to get him since December. I'm supposed to just give him back to her?
That's why she filed the
Excuse
motion.
me, Your Honor. Your Honor, I didn't understand the first question when you was talking about the alternate. I thought you was talking about parenting time. He has seen Kyle, but when I told him, he gave him to Carter, he haven't returned my baby. I dropped my baby off to Keon, to his mother house on Wayburn Street in Detroit, January 8th, and he kept him. I reached out to his mom. I have receipts of that. I reached out to his mom.
We're not arguing over that.
Oh, okay.
We're going back to the prior order.
Yeah,
Which means that next weekend, father has both children from Friday, is it 6 to Sunday at 6?
Yes, it is. If we can't get a great understanding, it'll be 6 to 6 for Friday to Sunday.
Well, that's what the court order is.
As they mutually agree, if they are unable to agree, then it is Friday at 6 to Sunday at 6.
Okay. So do we have an understanding? Both children are with mom until next Friday at 6 p.m. Father gets both children for the weekend. We go with the prior order.
I don't understand it, sir.
You don't understand it because he don't want it. He want
No, I don't
Carter and he
understand
want
it
me to
because
keep,
you abandoned
Your
your
Honor, he
child
want me
for
to keep
3
one
months.
first.
That's what I
We've
don't
had
understand.
allegations of abandonment. We
Mhm.
also had allegations of trying to find a different daycare. And frankly speaking, I've heard both arguments and I'm going back to the prior order.
Now, Your Honor, can I say this? If we're going with this and he don't be consistent, how do we go from there? Because we always
Contact in front of the court.
Okay.
Show cause hearing.
Yeah, they-
And on the flip side, if dad's not getting his weekends,
Mhm.
dad should be contacting in front of the court and saying, look, I'm not getting my parenting.
I always
She needs
contact
help.
her at the court. I send y'all nothing but proof about what goes on.
I don't
Nothing
get
is being done.
I don't get that. Ms. Schultz?
Just to clarify, a friend of the court can't enforce and make a parent exercise their
No, that's not the
parenting time.
point, but make the complaint.
If time is being forfeited, that needs to be motioned to the court to have the order. We can only enforce denials.
So, Your Honor,
So if there's a denial, contact them.
Your Honor, I will be getting my child back today
Yes.
because I haven't seen him. And I've
That's
gotten
what
him
you told
back.
not to. Your
Sir,
Honor, Your Honor,
we're not going to argue about this.
that's fine.
The
Can I
child-
say
Thank
this,
you.
please? She has called me, my mom, and my best friend for a week straight. This is for the same child that I'm not letting her see. I bought him a pair of shoes. I'm going to bring him over to see if he can fit them. 2 weeks went by. You still ain't came by. It's not that I'm not letting her see this child. She's choosing not to see this child. That's her choice. I'm not going to force her to see him. If she says she don't want to see him, that's on her. She's choosing not to see this child, Your Honor. I'm not keeping this baby from her. That's not the type of person I am. She don't want to see this baby.
I'm not saying you are, sir. I'm not saying you're keeping the child away from mother. Mother filed a motion under proper circumstances to get the child back. That's all. The child will be returned today. That'll be all.
Thank you.
Follow the court order.
So much.
193 DS. This is a show cause regarding allegations against Ms. Camacho. She is present. Mr. Henny is present. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Your Honor, an order was entered, stipulated order of support was entered on May 26th, 2022. granting the parties joint fiscal custody, for Mr. Henny having every weekend parent time from Friday at 6 to Sunday at 6, with the exception of the second weekend of the month, where Ms. Camacho would have parenting time. That order also states that neither party shall have members of the opposite sex overnight during their scheduled parenting time. We have 2 show causes on for today. One against Ms. Camacho for denied parenting time, and one against Mr. Henny for alleged overnight guests of the opposite sex.
Oh, yes, I forgot to mention that.
Back on August 5th, 2022, we were before the court on a show cause for denied parenting time, at which time at that hearing, the court had found Ms. Camacho in contempt for violating the parenting time order. No sanctions were imposed at that time. The parties had agreed at that hearing that the right of first refusal would be removed from the original order. So again, as I stated, we do have a show cause today against Mr. Henny for allegedly having members of the opposite sex overnight during his parenting time. I believe Ms. Camacho had stated in her complaint, also a reason for denying parenting time of melatonin being given to the child. I'll let the parties explain a little more of that, Your Honor. But we've had a complaint from Mr. Henny that he has not seen the child for the weekend of February 2nd and the weekend of January 26th to January 28th. And we also received another complaint on February 21st stating he did not have a child for February 16th, 17th, or 18th. So we have received numerous denied parent time complaints since this time.
February 2nd, just one day?
That week, the weekend of February 2nd.
Oh.
2nd, 3rd, 4th. 2nd, 3rd.
So we're talking 9 days.
So January 26th, 27th, 28th, February 2nd, 3rd, and 4th. And then the other complaint on February 16th, 18th, 19th.
Or 17th.
16th, 17th, 18th. Yeah, sorry.
No, that's okay. All right, let's begin with the alleged denied parenting time. Sir?
It's just simple. She's just been denying me parenting time. I just want to see my kid.
Did Ms. Camacho tell you why she was denying parenting time?
There's all kinds of excuses, Your Honor, and none of it's true.
She's I heard melatonin. I read that. And actually, I saw it in a text message too. How do you respond to this melatonin issue?
I've never given my son melatonin until she told me that she was giving him it. And I looked on the bottle and it said 1 gummy, before sleep. And that's what me and my sister followed. She was watching him while I was at work.
Okay. So how do you comment regarding having members of the opposite sex over when you're supposed to have your time?
It's not true, Your Honor. All I do is work, and when I'm not working, I'm with my kids. I don't have no interest with any other women because my last relationship was just terrible. I just don't need to be around them.
So are you saying you don't even have a significant other?
No, Your Honor.
Okay. How old is the child? I don't want to mention the child's name, but how old is the child?
It'll be 3 in May.
All right. Mom, how do you respond to all this? And your complaint against father relative to members of the opposite sex.
Okay, so as it states in our court order here, it says, where is it? Neither party shall have overnight guests of the opposite sex during his or her periods of custodial time until the further order of the court. So I had called front of the court to have that verified and cleared of what that means. So that states even your sister cannot stay the night because I was trying to move into.
That's not correct.
I actually called to see if I can move in with my cousin, and they told me that because of the way it's stated in our court order, it's so vague that it wouldn't be capable of me living with my first cousin.
Who did you speak to at the front of the court?
It was somebody that had answered the phone. I'm not sure of the person's name.
Male or female?
Female.
Oh, Your Honor, the order itself doesn't specify unrelated. It only states individuals of the opposite sex.
I see. Okay. That's probably why.
That, and Your Honor, that was probably put in there because of we had the right to first refusal for during periods of time when the other parent is unable to care for the child directly for 4 hours or more. So when that got taken out, that was like a security for not having, because he doesn't have to have a significant other, but he can have a sexual partner. Regardless if it's his sister there, and because there's times where he has claimed that his sister is babysat, and there's reports of her staying with somebody else at times of him saying that she has babysat, but I can't get those reports because it's in a court like proceeding. So I wasn't allowed to get that. Yeah, between her and another person there. So I wasn't allowed to obtain the police reports.
Let's just take a time out for a second. The issue of members of the opposite sex deals with not primarily, but exclusively significant others. In other words, a girlfriend, boyfriend. I mean, it's 2024 now. It doesn't matter, gender or otherwise. A significant other in a romantic relationship. That's what it's supposed to say.
Right.
But I understand why. I can understand why the front of the court may say that, because it is not clear in the documentation. So my question to both of you is there any objection to modifying that order to reflect members or any significant other, what I mean by a romantic partner, rather than a family member, because it is not designed for family members, not at all.
Well, I'm not saying like I care that his sister's staying there.
No.
At all, but that's with it being so vague. I have a police report of me calling to have a home check, and the police officer didn't do anything,
But what I'm saying is I'm willing to forego all of that. And if the parties agree that it's regarding significant others, that would make sense, because then you can move in with your cousin. Your sister can be involved. That's what I'm saying.
His sister is the one that's been giving my son melatonin.
Well,
when it's not supposed to be given.
Well, again, let's back up. Do you have any objection to modifying the language to reflect significant others rather than anyone?
No.
Do you have any objection, sir?
You're talking about my sister?
No, I'm talking about significant others. I'm talking about romantic partners. That's the thrust of why these things are placed in court orders, so as not to confuse the child.
That's correct. I mean,
So you don't have any problem with removing that portion either?
I think that I like it the way it is. I mean,
so that, in other words, if you're living with your mother, you can't have the child there.
no, not like that, of course.
Well, that's what it says.
Well, I guess I'd like it changed then, if that's.
Okay,
how it's being-
I would agree. The whole idea of this is regarding significant others so as not to confuse the child. Court will order that provision, Ms. Schultz, is modified to reflect significant others. That doesn't pertain to any gender or any preference. It's a significant other in a romantic relationship. Any question about that, Schultz?
No, Your Honor, and my recollection is that when I had initially met with the parties, that was their agreement, but it looks like that is not what was translated.
Agreed. Okay, we've addressed that. Let's talk about why the child did not go to dad.
On the simple fact of his sister has been giving him melatonin on times that she shouldn't be giving him. One was for a nap. She gave him a half of one and then gave him a full one at bedtime. And I have stated to her, I have even submitted, like wrote out a thing like to keep James on the same schedule, because when I had him in daycare, he was going to his father's on the weekend, and while his sister was babysitting on Monday, take him to daycare. By Wednesday, we would get him back on a schedule. Thursday, we'd have one good day, and then Friday, he would have to go back to his father's. And even the daycare was complaining. The daycare is closed now, so I couldn't have the daycare supervisor subpoenaed to verify that.
So the primary reason you're denying the parenting time is because the child's receiving melatonin from his aunt.
Yeah, which we have joint legal and joint physical, and if she's been giving it to him at half of one at nap time and a full one at bedtime, like that to me, that's way too much.
How are you getting the information other than I saw a text message?
She's verbally has spoken it to me and in text messages.
Okay.
And then for his denial of parenting time for his first complaint, for Christmas, it was verbally agreed upon that I had.
Oh, we're not talking about Christmas. We're talking about January 26th through the 28th.
Oh, I'm
2nd, 4th, and February 6th.
I'm sorry, I thought he had filed a complaint for them. I'm pretty sure I thought I received something for that complaint.
Was there Christmas involved as well?
Look at that.
Oh, no, there is one.
That was his initial complaint.
Christmas break.
Yes.
Parenting time during the 2023 Christmas break and weekend of January 26th. So it's Christmas break as well?
It looks like the notice from December 27th was denied parent time from December 22nd at 6 p.m., December 25th at 10 a.m. So the first portion of Christmas break.
Okay. So why was the father denied?
He wasn't denied. I asked him previous to him filing that complaint to swap because of my schedule with my other child. I was supposed to get her for the first part of Christmas break so that she could have see her sibling. And when I had messaged him on Christmas Eve and we were texting back and forth, which I thought I submitted the text messages, but apparently I must have forgot or they didn't go through, of messages between Matt and I stating that he could get JH on Christmas Day at 10:30 and he never showed up.
Okay, but the child was supposed to be with dad on the 22nd. Is the child with dad on the 22nd?
No, because I was supposed to get my child and then he knew about it, but then he didn't even show up, like say that he wanted to meet, because we're supposed to have public meets and he didn't even meet anywhere for the public meet. Along with one of the times that he's complained, I have evidence of it on my phone. I didn't submit it because I didn't know that he filed the complaint of just recently of him saying that I denied him time, saying that to meet at the Clark at 6 o'clock, but didn't specify which Clark station. And I went there at 6 and just before 6:30, and he never was there. And then he said that him and his sister was at the Pigeon Clark station.
And what Clark station were you at?
Caseville, because that's the only Clark that I know. Pigeon is the Pigeon One Stop is what it's called. And there's a Clark in Elkton.
I'm assuming to effectuate parenting time, because you have communication with each other, you met halfway somewhere.
He lives in Pigeon and I stay in Caseville at my parents'.
Oh.
Yes.
I see. Okay. Mr. Henning, what do you say about all this?
Regarding what she was just talking about, that was last weekend. And I never filed anything about that because I was actually sick and I really didn't think it was fair for me to file anything because of me being sick, because my son wouldn't have had any, I didn't want to get him sick on top of it.
Well, let's talk about Christmas break first.
I don't remember any conversation about us switching our arrangement.
Well, why didn't you pick the child up on the 22nd?
I tried to.
You tried to?
And she denied me. And then, but
Hey, tell me about it.
But the thing is, even
Back up. Tell me about that. Did you go to the location? Did you text her? Did you?
I was texting her and she was telling me she wasn't going to.
Close. Is that ordered here in this case?
No, but I'd like for that to be ordered.
I actually sent him, like I downloaded the App Close app and sent him a link and he hasn't did it so that we could use the App Close.
Okay. But so you're saying that you went on December 22nd?
No, I was messaging her and she was telling me that she wasn't going to let me.
Okay.
But the thing is, if that's how it was supposed to be and I was supposed to get him the second half of the vacation, I tried to get him that whole time. She would not let me have him at all.
Okay. What about February 2nd? I'm sorry, January 26th, 27th, 28th?
It's just a normal thing where I message her usually on a Friday, like, are you going to let me have him or not? And she basically tells me no.
What about February 2nd, 3rd, and 4th? Same thing?
Same thing.
16th, 17th, and 18th, same thing?
Same thing.
How do you comment, or what do you comment relative to this melatonin usage?
I went by what the bottle said. I mean, if it was that big of a deal, I'm sorry. I know I apologized to her for it. It could be corrected, but I think she's making a big deal out of something that was just a simple mistake.
Mom, what do you want from melatonin?
The only reason why I had asked for the melatonin,
I'm asking what is the dosage that you are?
What it states on the bottle and what his doctor had said in an appointment to follow what is on the bottle, which is 1 at bedtime if needed.
Okay.
And I did write that out. I tried getting the thing from the doctors where her dictation notes of where it was talked about, and I didn't get it in time to bring it here.
Bottom line is 1 at bedtime as needed.
Yes, as needed,
Do you
because
have any
it's,
problem with that, sir? That's what it says on the bottle, I'm understanding as well, or not? What does it say in the bottle?
one at bedtime.
I don't remember the bedtime part, I'm sorry.
Okay. Do you have any problem with 1 at bedtime?
No, I don't.
Okay. All right. Regarding the refusal, we're talking melatonin. That's the primary reason. There could have been discussion between the parents relative to that, but there wasn't. It's just, I'm just denying the parenting time. I find the parenting time denial to be wrongful. I will order makeup parenting time for father from the February 16th, 17th, and 18th dates, January 26th, 27th, and 28th, February 2nd, 3rd, and 4th, and for the 2024 holiday relative to Christmas holiday season, if that's what we celebrate, father will have the full Christmas break.
Your Honor, can I say something? I didn't get to file a parenting time complaint about, for Thanksgiving, which that was one of the text messages that I had sent and submitted.
Go ahead and file it. Court will hear.
Well, right, but that's what I'm saying, like, that's why the parenting time was different, because it was basically, I had Jameson for Thanksgiving, and then when he realized that it was supposed to be his holiday, he was at the bar drinking.
File a motion, Mr. Macho.
But that's the same thing with the Christmas vacation.
I made my findings, and that's the court order.
That'll be all. Thank you.
You are ordering applicals.
Oh, yes, app close I'm going to order as well.
And then to file a motion to have it to where we can have the right to first refusal, how do I do that?
I can't give you legal advice. But,
We just filed a motion through the.
Well, you
I
can
would
file a
rather-
motion if you wish, but I always encourage someone to consult with an attorney.
Is there a way that we can put that back into our order?
You're the one that took that out because she was using it against me, denying me
She
time.
can file a motion, whatever she wants, just like you can file a motion, sir. But she has to file that motion. That's not before the court. We're on the refused parenting time. We are here, melatonin issue. We've addressed the melatonin issue. Regarding sanctions, I'm not ordering any sanctions. I didn't last time, but the Christmas break, no.
The whole truth, nothing but the truth, so help you
That'll
God.
be all. I'm sorry, I didn't hear your.
Yes.
Okay, thank you. Mr. Holt.
Thank you, Your Honor. So we are here on a show cause against both parties, actually. The show cause is for alleged denied parenting time that Ms. Varellen had denied Mr. Kester parenting time for the weekend of January 26th, 27th, 28th, I believe. No, sorry, that's a misprint, Your Honor. The complaint had stated that Ms. Varellen got the child a day early and then did not return the child for father's time after that. And the messages that were attached, my understanding was there may have been a switch in parent time at some time and she was taking makeup parent time, but there was never anything filed with our office regarding denied parenting time until this complaint from Mr. Kester. So it appeared that it was I missed my time, I'm going to take my time back type situation. So that's where the show cause.
I'm really confused because it said
The motion indicates defendant allegedly denied parenting time, failure to use app close, and weekend of January 26, 2024 to January.
Correct. That's a typo, Your Honor, because the complaint says January 11th.
Okay. Yeah, so it would be January 11, 12, and 13.
My understanding is that Ms. Varellen got the child early on January 11th. So that would have been Mr. Kester's day. And then when the child was to be returned to dad for his next time, the child was not.
So who has the alternate weekend?
Mr. Week to week currently.
Oh, it's week to week currently. What is the exchange supposed to be?
I believe Fridays, Your Honor.
January 11th is on a Thursday.
Yes, that would have been a day early, so Fridays, Your Honor.
If you don't mind to help me out, what it was is that Thursday she called and before that Thursday she called and said that her and her husband's family was leaving. Her husband's family was leaving, and asked if she can have her a day early because the family wanted seeing her. And I said, yes, how long did I get her back a day early? And we agreed upon that, and that's what happened.
Okay, so
So that's why she ended up getting her on a Thursday instead of a Friday.
okay, so normally on the 11th, that would have been your day.
Yes.
Is the 12th your day?
Till 6 o'clock at night. On Fridays at
That's when the exchange is.
Yeah, Fridays at 6.
So you're,
Sorry, Your Honor. I don't mean to interrupt. Looking at the messages that were attached, there's a message from Ms. Brown that says, when do I get my makeup time? Mr. Kessler saying, how do you have makeup time? And it appears there was an audio call through Facebook Messenger, and then a message after that from Ms. Brown that said the weeks that she was sick. So, and then another audio call, which plays into the other portion of this show cause, which is against both of them for not using that close as ordered. Because looking at messages that were attached and provided to our office, they're communicating through Facebook Messenger. There's a question, then there's an audio call, and then there's more communication through Messenger, but none of it's through at close, which is a violation of the order.
right.
And then also, Your Honor, just on the 27th of February, we received another complaint from Mr. Kester that he was supposed to pick up his child on February 16th for visitation. Was at the meeting location for a half hour, tried calling, and at 6:30, no answer. He had texted Miss Rellen, and then was told he was not going to get the child. And it appears a conversation was attached, again, not through app close, regarding allegations of bed bugs.
Okay, I think I've got it, I hope. So father lost, or maybe a part of an agreement, I'm not sure, we'll find out. I didn't hear from the other side. Gave up the child a day early because mom had her significant other's family members over. Dad would normally have the child on not only the 11th, but the 12th until 6 p.m. And then the child would go back to mother, correct? Okay. February 16th would be the normal day of exchange, correct? And you'd have the child for a whole week. When did you get the child back?
I had
Not even today?
not till 6 o'clock tonight, and I don't even know if I'm able to do that because in those text messages, she told me I have to prove that I don't have bed bugs.
Okay, so how many days have you missed from February 16th?
1 week.
1 week? And Mr. Kester, you're claiming that mom is denying you because of a bed bug allegation?
Yeah. Someone, wait.
Okay, well, is there a bed bug issue?
It's all my house, clean. I had my landlord come in and double check everything.
Didn't we have this issue before?
No, that was the-
Another one. Okay. So you say there is no bed bug issue. Mom, I'm assuming claiming there is, based upon what?
My daughter having bed bug bites all over her every time I get her back.
Did you go to the doctor regarding that?
Yes, I have. I have taken my daughter to the hospital multiple times.
And you're claiming the doctor says it's bed bugs?
Sometimes they say bed bugs, but then the last time they want to say it's flea bites because of the dog in the house, but it was clearly bed bugs because it's only been a week old.
Where's the dog?
I do. Well, actually, both parties had
Dogs.
dogs in the house.
But mine are
So
treated.
either dogs, any of the dogs can carry fleas potentially. But so, Mom, when you claim you made this discovery, did you have a discussion with Dad about it?
About him?
About the bed bugs?
I've asked about the bed bugs multiple times.
No, I asked, not asked about, did you have a discussion with him about
He denies it all the time.
it? Okay.
But he's also verbally said that she's the only one that's being bitten up because it's in her room.
Can you repeat that? I didn't understand that.
I said he denies that she has bed bugs, but he has admitted that she is the only one getting bitten up because they are in her room.
So that's the exclusive reason for your denial, correct? The bed bug issue?
I would love to give her back if he just gets rid of the bed bugs.
I don't know if there's a bed bug issue or not.
And I'm not going to the house to find out, but
I
How do
mean,
we
he has
resolve
verbally
this?
told my mom, he has verbally told our daughter's teacher that he has bed bugs in his house.
I have talked to the teacher, and the teacher has also noted. and
okay.
Tried,
We're-
hold on.
wait a moment. We're going into hearsay as well.
Anything that the teacher may have said, or that the teacher may have heard from father would not be considered hearsay, but the teacher has to say it, not the parent. That's hearsay upon hearsay. So one party's claiming there are bed bugs, the other claims there isn't. I don't have a doctor report. I don't have anything to go on. What I do know is that there's an order saying that the parties are utilize app close. They're not utilizing it.
I have it. I have it downloaded. I have an account. I have sent him multiple links
Yeah, but you're communicating back.
because he won't use it.
So I find you both in contempt.
Don't.
Time out. We're not losing control, sir. I find you both in contempt for failing to use app close. That's a court order. It needs to be fulfilled. I will require by the end of business today that the app be installed on your phone, sir, and that exclusive communication other than emergencies. What I mean by emergencies, medical emergencies, even the emergency of we're supposed to exchange at 6 o'clock, but I won't be there until 6:30. I can understand that being a phone call or something else. But otherwise, all communication is to be utilized by app close. Regarding this bed bug issue, though, I have no idea. I mean, have you contacted exterminators? Have you had it? I don't know. What's going
We need
on?
to call the exterminator. It's gonna cost almost $5,000 to have them come out.
Miss, I don't need the commentary, please. $5,000 for someone to come out?
Because they're gonna want them out, street house, everything, because we're gonna have them come out like with the street house. Because she just wants, it's still gonna cost me more money than what's in my pocket right now.
Well, I have no indication whether it's bed bugs or not. I don't know.
Yes, there's been bites on my daughter. Me and my brother's been going out buying sprays. We're not just spraying just for fleas. We're just spraying for everything. Just to make sure it is nothing. To make sure the house is clean and safe for the kids. And I'm doing my best.
So you're aware of a problem then, but you don't know whether it's bed bugs or not because you've been buying sprays.
Yes, we've been buying sprays. I just talked to my other brother because I told him, because I told him what was going on and how she catches pallets with her. You have something else that maybe will help with everything in the house. He says, well, he's going to go out and he's going to buy some kind of spray and have me try that.
Do you have any suggestions?
It's not the fact that I'm keeping her, I'm protecting her from her getting bitten up because she keeps coming to me covered head to toe in bites. And I have mentioned this multiple times.
But I have no information from a doctor.
I can get doctor reports.
Do that. Get some doctor reports because I can't make a decision relative to whether it's wrongful denial or not, because it could be fleas from the dogs, from any of the dogs. I don't know.
Dogs have been treated, please.
Miss, I don't know. Give me the documentation. We'll reconvene in 2 weeks. In the meantime, is there another room in the home that, are you experiencing any of these bites?
No.
Why don't you swap beds for a week and see how
I
that
was
goes?
talking to the school teacher and she hasn't got it back on me of what the laws are. But I know I can't have her and my 7-year-old in the same room. But we were trying to figure out if I am allowed to move in the same room as her, if it would be legal or not. Because she's only 2. You don't have a lot of toys in there. And we're trying to figure out, because I sleep out in the living room. And just do it that way, because I don't even know if I can even put her out in the living room by herself. And if I'm sleeping, she could be able to get into everything and not know.
I'm not going to come out as a lawyer or judge.
No.
Not
Not
to give legal advice here, but I'm not aware of anything that says a parent can't be in the same room as a child. I mean, that doesn't make any sense.
There is no law against it.
Yeah.
Well, I don't know because law keeps changing, so I wanted to double check before I make any decision and get in trouble for nothing.
When is your next week supposed to be?
It's supposed to be tonight.
Tonight.
At 6 o'clock.
Do you have another place where the child can sleep, not in the same bed? I mean, you're sleeping on the couch. I'm assuming there's
No,
no.
I got a queen size bed out in the living room.
Oh.
You can come sleep in my bed, I guess, if I have.
You're
to.
not
I don't
experiencing
care.
the bites, are you?
No.
Let's see what happens.
If I have to, she can sleep in bed with me. Much as I don't like my kids sleeping there, but I'll suffer for a week just to have her.
She might actually end up sleeping in bed with you because she's.
No, she likes sleeping at the foot.
Well, you can have that discussion later. We will be back in 2 weeks. The child is to come back to dad today, at the scheduled time, 6 p.m., which is the prior order. And the child is to sleep in the bed that father is sleeping in. And let's see how that goes for 2 weeks. In the meantime, Miss, you can get the documentation regarding any alleged bug bites. Then the court will make its decision on all of them.
So we're gonna wait for everything.
Yeah, we want to see what the doctor has to say. And then in the meantime, if they're, for the heck of it, it wouldn't be a bad idea to contact one of the local pest control agencies to see what they may charge.
All right.
5,000 sounds pretty darn high, but
I will
I
get a
don't
hold
know.
of my landlord when I walk out and let him know and have him deal with it.
Okay.
Or he might send me to his manager or whatever it is that's under him.
Can you give them notice then? You can print it out right now.
Nope.
Make sure you get that documentation, Miss. Bring that with you to the next hearing. And you're going to get notice of the next hearing right now. Otherwise, regarding the app close issue, the court's made its decision as not giving out disposition on that, but we'll address the parenting time issue when we come back. Thank you.
Truth, so help you God.
Yes.
As I understand it, we are still dealing with basically dispensing sanctions relative to the use of app close, and this was also a review to see what's going on in the home. Does that sound about right, Mr. Wolf?
Correct. At the last hearing, Your Honor, on March 1st, the court had found both parties in contempt of court for not following and utilizing the app close application that was previously ordered. There was a week of denied parenting time that was discussed. If I remember correctly, the issue of bed bugs was brought up. At the conclusion of that hearing, it was adjourned to today, and disposition was preserved from the last hearing on the contempt. But I believe the court had, due to testimony, marks on the child, but not where dad was sleeping. So it was discussed that they split rooms for the week or until we got here to see what was happening, and for him to provide the proof that there's no bed bugs, or if there was, that the issue was taken care of.
Because they go week on, week off.
Correct.
Esther, how did it go?
I want to first let you know I'm seeking legal counsel.
Oh.
I tried to get it in court before. What it was is he got laid up in court, so I haven't had a chance to go talk to him. Because some of the stuff I don't understand legal terms.
So you want to hire an attorney?
I don't know if we're going to hire yet, but we have a appointment today this afternoon to speak with him.
Okay.
To see what's going on.
So you're requesting this matter be adjourned?
Yes, sir.
Mr. Ellen, any comment?
Nope. I mean, I brought the record you wanted me to.
What record is that?
The hospital records.
Okay.
Well, the hospital record.
Well, why don't you hold on to those, and when do you think you'll have an answer regarding the attorney?
He's supposed to get a hold of us this afternoon, so I'd say maybe a week, maybe.
So
I'll keep you guys up.
Adjourn 1 week or 2 weeks?
Let's go with 2 weeks in just in case, because like I said, he's been backed up with his other caseload for another court case. Whatever that matter is, I don't know, because it's not my job, but he's been backed up, so.
It'd be April 5th would be the earliest here.
That's fine.
Is that okay with you?
Yes.
April 5th, 9 a.m. We'll give you notice
I
right
have
now.
a question. On that close app, does it have video chat? Because I paid for the last court paperwork, and it states that we're supposed to have videos, chat, phone conversation on both parties on, and if we can't agree on it on Tuesdays and Thursdays at 7:30.
Yes, the app does allow for regular text messaging, phone calls, and video chat on both ends.
Okay, so we can do the video chats with our daughter that way. Okay, thank you.
You have to enable that option within the app. So when you go into your call, right, it should pop up and ask if you want to enable video chat and calling feature. Just make sure you tell yes.
Okay, thank you.
But my thing is, she doesn't stay on the phone. She just only stays on the phone for 5 minutes to say hi, hey, I love you, and then she runs off. She will not stay on the phone for more than 5 minutes.
We're not in a corpus.
No,
And
I just had a question, that's all.
Oh, I'm sorry.
I'm sorry.
No, that's okay.
May I address that, John?
Please.
As it relates to talk time under the friend of the court policy, talk time is supposed to be pursuant to the child's preference. Obviously, your child's young, so if she just wants to say hello and continue on with her day, that's the talk time. It doesn't have to be a full half hour.
No, I didn't even think of that way, so.
Yeah, the
I was
child
just,
sets the duration of the talk time.
all right, thanks for clarifying. I just wanted to understand before we left.
Show cause hearing regarding, actually originally both parties. Regarding app close and some parenting time. Mr. Kester is present, represented by attorney Bernadine B. Trout. Ms. Rowland is in pro se. Will both parties please raise your right hands?
Do you solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Yeah.
Thank you. Before we go to counsel or any party here, Mr. Holden, can you give me an update, please?
Yes, Your Honor, we were before the court on March 1st for a show cause against both parties for failing to use app close, as well as a show cause against Ms. Burrellen for denied parenting time, I believe roughly a week at that time. At that hearing that week was discussed, there was a misunderstanding of the filing. Nonetheless, the court had found both parties in contempt for violating the app close provisions. Disposition on that violation was preserved, and the hearing was adjourned to March 15th due to allegations of, I believe, bed bugs at the time. The court had ordered Mr. Kester switch arrangements for sleeping within the child. Came back on the 15th to discuss that issue further. There was a week of, I believe, February 16th to the 23rd that was on the table for denied parent time due to the issue of bed bugs. But at that hearing on March 15th, Mr. Kester had requested an adjournment to speak with counsel. The court had granted that and adjourned the issue for today.
All right. Ms. Trout, what is the status of the bed bug situation?
Okay, so Your Honor, my clients have, they inspected the apartment for bed bugs. They didn't find any bed bugs in the apartment. They did contact some commercial pesticide folks, and all of them told them that they would have to go through the landlord because it's an apartment. So what my clients did, and the landlord, from what my clients are telling me, is suffering from some dementia. And so it's very difficult to communicate with him. So what my clients did do was go and buy pesticides and fumigated the apartment. Even though they didn't find anything, they did fumigate the apartment. And I also like to tell the court, Your Honor, that my client does have a 7-year-old son who has full custody of. That child has not exhibited any signs of being bitten by any bugs there, and neither has my client. And both of them live there in that apartment. But they did fumigate the apartment.
Despite the fact that there were no bed bugs found?
No, they never found any bed bugs.
Okay. Any comment regarding your client relative to the lack of use of the app close application?
Lack of the use of the app close. Well, Your Honor, that I haven't discussed in detail with him, but I can represent to the court that he has downloaded that app. He does have it, and that he will be using the app exclusively for communications related to the child.
Very well. All right. Ms. Rowland, your response. What would you like to say about all this?
Well, I mean, there has been cases of bed bugs in this house, not the fact that I found any, but I have reported to the hospital. I've had issues with it for probably about a year. But I mean, the only reason why she's getting bit is because of in her room, the room that his mother used to stay in before he kicked her out. Not the fact that it's in it's in the living room or it's in his son's room. It's mainly in Guinevere's room. So of course, that would be the reason why she's the only one getting bit.
All right, well, you did hear counsel state as an officer of the court that they went through the entire apartment, found nothing.
Bed bugs hide. They go on the walls, they go on the floors, they go underneath the carpets. Ask my mom, she's dealt with it before.
Okay.
My grandpa's dealt with it for 11 years. And his house got infested.
All right, what about the app close?
We both have it.
Okay. What about allegations of denied parenting time, February 16th to the 23rd?
He can have makeup time as far as I'm concerned.
Okay. All right, thank you. Ms. Trout, do you have anything further?
No, Your Honor, except for, yes, I do, Your Honor. I just like to represent to the court that mom did send me an email with some medical documentation. However, the child's name wasn't on it and the date was like March 28th. So it was.
No, it wasn't.
Just a moment, Miss.
And so I wasn't sure if that was the service date or what, because I asked mom to send me documentation with the child's actual name on it, the facility, and the date that she was served. But I didn't get a response to that one. Just to represent to the court that she did send me some documentation, but I just couldn't really discern whether or not there was timely in it that it was this child.
Mr. Holbrook, have you had any complaints regarding communication since our last case? No, Your Honor. Okay. Have there been any sanctions imposed previously?
No, that was the order entered, the complaint came through on the denied parenting time where there was that miscommunication. With that complaint, messages were found to be between the parties on Facebook Messenger after the order entered. So when the show cause came to denied parenting time, in front of the court brought the issue that closed because the order had entered and it was not being used fairly frequently after the order had entered. But I have not received anything since. So that was the first time the court found any contempt regarding that close at the March 1st.
Okay, thank you. All right, here's the court's ruling relative to any contempt relative to the app close. Court found contempt previously, but delayed the disposition until this morning. What I was looking for is to see what's going on since then. And what I've seen going on since then, according to Mr. Holwick, is that there have been no problems with communication. As a result of that, there will be no sanctions imposed to either party for the lack of use of app close, contrary to court order. But I want to make a clear understanding with both parties now. You use app close. That's what it's for. It avoids this issue. It keeps everything memorialized. And most importantly, it keeps parties communicating with each other. And that's the whole goal here when you have a minor child involved. So I'm not imposing any sanctions relative to that. Relative to the denied parenting time in this case, according to mother's testimony, she stated that she has no objection to him, that his father, getting that week back. So February 16th through the 23rd, whatever the amount of days are, the court will order that makeup time to be done to the hearing based upon the policy from the court's makeup parenting time schedule, which I believe must be done in 6 months. Right. So if there are any questions regarding that, regarding getting your makeup parenting time, sir, I direct you to the front of the court to address that, but I'm granting you the makeup time for that February time frame.
So it's just the 1 week.
Your Honor, that was, I think his original, and I'm not privy of the past, so excuse me, but I believe that he asked for makeup for January 18th through the 26th as well. Has that been addressed by the court?
That was the initial complaint, Your Honor, and the party stated on the record there was a misunderstanding and that was taken care of. So there's only 1 week that the party stated was that issue, and that was that February 1.
Okay.
All that too. So it'd be the February time.
Thank you, Your Honor.
Purposes of the order, Your Honor, with show cause. So with Ms. Farrell's statement of granting the 1 week makeup parenting time, it's just show cause, just dismissed.
We'll dismiss the show cause, but we're just granting an additional.
Thank you, Your Honor.
All right, clean slate, folks.
Your Honor, am I to draft that order, or will the order come from the front of the court?
No, Mr. Holwick will draft it.
Thank you, Your Honor.
Save everyone some time. Clean slate, everyone.
Yes.
forward. Pleasure meeting you, Ms. Trout.
You also, Your Honor. Thank you.
You're welcome.